Good morning, everyone. Welcome to the Supreme Court of Appeals and welcome to our presentation today. At the moment of the state's creation, West Virginia was focused upon the tension between enemies and the rule of law. The word enemy itself comes to us from the 13th century, a contraction of the prefix "in" meaning not, and the word amicus meaning friend. So enemies, stands to reason, are not our friends. The early government of West Virginia leveraged the concept of enemy in order to preserve its sovereignty, and we discuss with you today three groups of interesting cases that focus upon this tension between enemies and the rule of law. I'm Rory Perry. I'm the clerk of the court, and I've been privileged to serve in that capacity for the past 7 years. It's humbling to stand on the shoulders of the collected history of the 218 volumes of the West Virginia reports. And so during some of my downtime, listening to always interesting oral arguments here in the courtroom, I started reading the early volumes of the West Virginia reports. The first 7 or 8 are up here on the table. And I discovered that the early reporters are replete with interesting conflicts that followed the state's entrance into the Union in the crucible of the Civil War. And so we explore those tensions with you today. With me is Joshua A. Lynn, a Marshall University Yeager Scholar, who for the past several weeks has been plumbing the archives in order to find material to support our connections today. And Josh is largely responsible for the historical connections and context that we'll be discussing with you here today. So this is truly a partnership presentation, and bear with us as we stand up and sit down. Hopefully it will be interesting to you today. We will be reserving some time at the end for questions, and we thank you again for your attention. At the moment of the state's creation, 40% of the population became automatic enemies, Confederate supporters, hostile to the state, and as such lacking in full legal rights. Suddenly, West Virginians loyal to the Union felt surrounded by enemies. And what was most sinister about these enemies was that they were often former neighbors, friends, and even government leaders. They weren't necessarily conspicuous and didn't seem always sinister. The fact that early West Virginia leaders were painfully aware and protective of their own status in view of these enemies dramatically affected how the rule of law was shaped and how the executive, legislative, and judicial branches of government would frame their view of sovereignty. One of the touchstone issues during this time period was the test oath. And so we begin with our first group of cases, the test oath cases. Test oaths were passed by the West Virginia legislature during the final years of the Civil War as a way to guard against Confederate infiltration of the government. The standard test oath required before engaging in many civil activities in West Virginia went as follows. And I'm going to pretend I'm Ralph Berkshire, the first Justice of the Court. I, Ralph Berkshire, do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, that I have never voluntarily borne arms against the United States, that I have voluntarily given no aid or comfort to persons engaged in armed hostility thereto by countenancing, counseling, or encouraging them in the same, that I have not sought, accepted, nor attempted to exercise the functions of any office whatever under any authority in hostility to the United States, that I have not yielded a voluntary support to any pretended government, authority, power, or constitution within the United States, hostile or inimical thereto, and that I take this obligation freely, without any mental reservation or purpose of evasion. Quite a mouthful. And we have on display here a page from our early order book. That's in fact the handwritten oath that I just recited that Ralph Berkshire, one of the first justices of the court, took in Monongalia County in front of the local judge in December. After the war, Confederates repeatedly challenged these oaths before the Supreme Court of Appeals in order to re-enter civil society. Studying how these cases were decided in the Supreme Court of Appeals illustrates how the rule of law, the status of enemies, and the definition of rights ebb and flow with political currents.
The historical context of West Virginia during the Civil War and then subsequently Reconstruction contributes to our understanding of why the West Virginia legislature felt that test oaths were essential and why the Supreme Court of Appeals consistently maintained their constitutionality. West Virginia, of course, was a unique product of the Civil War, and when it entered the Union on June 20th, 1863, it did so with a divided populace. 24 of the 34 most northwestern counties of the state were firmly in Unionist hands and accounted for approximately 1/3 of the state's land area and 60% of its population. In contrast to that, the counties that were predominantly composed of Confederates and Confederate sympathizers accounted for 2/3 of the state's land area and 40% of the population. Thus, upon the state's creation, West Virginia was full of enemies. And this state of affairs is important to keep in mind in order to understand how politics played out in Reconstruction-era West Virginia, with fierce and bitter partisanship and the need felt by one side not only to call the other side political foes, but actual enemies of the state. During the war, Unionist Republicans controlled the state government. They supported the admission of West Virginia as a new state and were loyal to the Union during the Civil War. They also passed many prohibitive measures against the Confederates within the state, such as property forfeiture and electoral disenfranchisement. And one of the most important of these measures was the test oath. A test oath differs from a standard oath of allegiance like that required today of officers of the government because it requires a denial of past criminal activity or the holding of suspect beliefs, and as such functions as an instrument of compulsory disclosure. In 1863, the first test oath was passed by the West Virginia legislature, applying to all officers of the government, civil and military. In 1865, as the Civil War was ending, a test oath was also approved for voters whose loyalties were suspect during the war, and also for all those who were suing for a rehearing of a case in court, and this latter act was aimed mainly at frustrating the efforts of ex-Confederates returning home from the war who wanted to use the court system to regain property seized during the war. However, after the war ended and as the nation and West Virginia entered Reconstruction, test oaths continued to be important in Reconstruction-era politics. Republicans, now radical Republicans, controlled the state government. These Republicans were not only supportive of the Union during the war, but after the war, they sought to punish the Confederates, whom they blamed for causing the war. And thus, in 1866, the test oath was extended to cover attorneys, all voters, and election officers. And in 1867, public school teachers had to submit to taking the test oath before being hired. The test oath contained both idealistic and practical implications for the Republican government. Idealistically, it was a way to remake society without the influences which they claimed caused the Civil War in the first place. But as Reconstruction progressed into the late 1860s, it assumed a much more practical political purpose. The Confederates who were disenfranchised by the test oath and who were barred from holding office were almost always Democrats, and thus the test oath silenced the opposition and maintained Republican rule throughout the state. However, in addition to the legislature and their acts during this time, it's very important to examine what the Supreme Court of Appeals was doing in regards to test oath and how they were instrumental in upholding Republican rule during Reconstruction. But it's not enough just to look at the actual cases that went through the court at this time. We must also look at the actual makeup of the court. Under West Virginia's 1862 Constitution, the Supreme Court of Appeals originally consisted of 3 justices. Those first justices were Ralph Berkshire, William A. Harrison, and James H. Brown. In 1867, a 4th justice, Edwin Maxwell, ascended to the bench after Harrison resigned. All of these first justices possessed impeccable Unionist credentials and were ardent Republicans, contributing to what historian Ronald L. Lewis calls the Unionist court in West Virginia. For example, Ralph Berkshire, whose test oath you heard earlier, was active in the state's formation and was a delegate to the Wheeling Convention, which renounced Virginia's Ordinance of Secession. William A. Harrison, like Berkshire, was a strong Republican and was active in the statehood process in West Virginia. James H. Brown actually began the Civil War as a Unionist Democrat. However, he joined the Republican Party after most Democrats sided with the secessionists. During the war, he served as a circuit court judge and several times had to flee to evade the capture of his court by Confederate raiding parties. During the statehood process, he and others were known as obstructionists because they actually slowed down West Virginia's statehood, advocating that more of Virginia be incorporated into the new state. And lastly, Edwin Maxwell was a Republican member of the legislature and a Republican attorney general who actually argued the constitutionality of test oaths before the court before he actually ascended to the bench in 1867. And thus, the political views and Unionist sympathies of the first judges is important to keep in mind as we move into a discussion of the actual cases which decided the constitutionality of the test oath. Soon after the Civil War ended, as ex-Confederates returned home and sought to regain their antebellum lives, they found themselves in a new state that was in many cases hostile to them. The earliest major challenge to the test oath was undertaken in early 1866 by attorney Charles James Faulkner. Faulkner himself is an intriguing character and merits attention as an active political force in West Virginia politics decades prior to and after the Civil War. In 1861, when the war broke out, Faulkner was serving as the American minister to France, and upon his recall by Abraham Lincoln, he returned to Washington, D.C. and was imprisoned by the federal government, held as a hostage for the state treasurer of Pennsylvania, who was held by the Confederate Army. During his imprisonment, he repeatedly refused to take the federal oath of allegiance because, and quite rightly, he claimed he had shown no signs of disloyalty up till that point. However, after he was exchanged for Confederate-held Union prisoners, he immediately showed his signs of disloyalty by traveling to Richmond, meeting with Confederate President Jefferson Davis, and becoming General Stonewall Jackson's chief of staff. He would serve as a lieutenant colonel in the Confederate Army until the surrender at Appomattox, upon which he returned to his native Berkeley County.
Faulkner made a small vocation out of challenging test oaths in court. He began with a pro se challenge to the test oath, but not on constitutional grounds. In 1866, the court decided the case of Ex parte Faulkner. Now, at this time, William Harrison, one of the original three members of the court, was absent quite a lot due to illness. So the opinion in the court was authored by Justice Brown, with Nathaniel Harrison, a judge in Harrison County, appointed by special assignment. So actually, two judges decided this first challenge. Faulkner argued that the original Test Oath Act only applied to state officers. He wasn't a state officer as an attorney, so therefore he didn't have to take it. So he got in under a technicality. Faulkner's victory would parallel some events that happened on the national level. Congress passed what was known as the Ironclad Test Oath, which West Virginia's oath was patterned after. Similarly, some federal attorneys challenged the test oath's applicability to them in the U.S. Supreme Court. The U.S. Supreme Court ruled that it didn't apply to them, so Congress quickly passed an act that would require federal attorneys to take the test oath. Similarly, Faulkner's victory in the Ex parte Faulkner case was very short-lived. 1 month later, on February 14, 1866, the legislature passed an act that would apply the test oath, in fact, to attorneys. There wouldn't be another successful challenge to the test oath until 1872, so for about 5 or 6 years, from 1867 to 1872, both the legislature and the Supreme Court were firmly in Republican hands. Ex-Confederates could only bring suit after fruitless suit. One of the most important of these subsequent challenges was the 1867 case of Ex parte Hunter, in which the constitutionality of the test oaths were challenged by 5 ex-Confederate attorneys, each of whom had received a presidential pardon from President Johnson. Again, Justice Brown authored the opinion of the court, with William Harrison absent and Judge Loomis from Monongalia County, who would be the subject of a very interesting election battle in 1872 that the report on that case takes up about 85 pages in the volume of the West Virginia Reports. Anyway, he and Justice Brown authored the opinion of the court in Ex parte Hunter. Counsel for the 5 ex-Confederates was Charles Faulkner. Counsel for the state was Edwin Maxwell, who was Attorney General at that time, who would later become a justice. The primary issue in this case was what, in fact, is the effect of a federal pardon. He'd been pardoned under President Johnson's presidential Reconstruction program, the point of which was to try to get those who were instrumental in part of the rebellion back into public life. By giving them a federal pardon, they were able to re-enter public life as part of the Reconstruction program. The Supreme Court of Appeals here in West Virginia was asked to consider what's the effect of those pardons. In an act of what might be called judicial federalism, the court said they have no effect whatever. In fact, all they do is restore whatever rights can be granted by the federal government. And because the state, not the federal government, has the power to control and regulate attorneys within its borders, a federal pardon means nothing at all. The decisions in the Ex parte Hunter case also demonstrate the strong unionist sympathies of the judges. There were two opinions in this case. Both Brown and Loomis authored opinions. Judge Brown explained that the legitimacy of the test oath, quote, springs from the propriety and necessity of keeping the temples of justice pure, and the duty of the courts in permitting none to minister there who are unworthy. Judge Loomis, who was filling in, justified the disbarment of ex-Confederates, claiming, quote, that the rebellion was treason in its worst and least mitigated form, and that Confederates had sinned against the light. Following Ex parte Hunter, there were several other decisions that upheld the constitutionality of test oaths that had been enacted in other contexts. The jurors' test oath was found constitutional in 1868, and the voters' test oath was also upheld. The 1870 case of Pierce versus Carskadon serves as a telling example of how ex-Confederates were viewed as enemies and how their rights were restricted accordingly. Pierce versus Carskadon was again authored by Justice Brown, with William Harrison absent, and so the only judges in this case were Brown and Edwin Maxwell, who was now on the bench. It was decided in 1870. Now, Pierce was a soldier in the 7th Virginian Cavalry of the Confederate Army. During the war, his unit stole several of Carskadon's horses. While Pierce was still away at war, Carskadon sued him and obtained a judgment of $700 in December of 1864. So when Pierce returned from the war, he went down to the courthouse to file a petition for rehearing, except there was a statute. It said, if you want to file a petition for rehearing of any judgment entered in the last 5 years, you have to take the test oath. So Pierce couldn't do it, and he brought the case to the Supreme Court. The major holdings in the case are that enemies in war have no right to use the courts of the adverse party. The war gives the right to forfeit and confiscate the property and debts of the enemy. The state can use its sovereign as well as its belligerent powers, that is, the powers that the state has during a time of war, in order to suppress the rebellion and punish the insurgents. Accordingly, the rehearing test oath is not unconstitutional. An interesting sideline on these cases is that just as the Republican legislature used test oaths for the political purpose of maintaining those in power, there were efforts to use them for personal gain, personal purposes. For example, there was a man named Nathaniel Harrison who may have been the same Nathaniel Harrison who sat on one of the early test oath cases. I haven't quite figured that out yet. But nevertheless, in 1870, he brought a cluster of cases in which he attempted to use the test oath as a shield to preclude his creditors, who were Confederates, from collecting debts that he owed them. And the court held that, no, we're not going to go that far. The test oath is really a wartime measure, and it can't be extended to such personal purposes.
Despite the Supreme Court of Appeals' consistent maintenance of the test oath's constitutionality, outside political forces would eventually end the era of the oath in West Virginia. In 1866, the United States Supreme Court ruled in two separate cases, Ex parte Garland and Cummings versus the state of Missouri, that test oaths at the federal level and in the state of Missouri were unconstitutional. However, West Virginia's justices, while acknowledging that they were familiar with this ruling, maintained that West Virginia was still a unique set of circumstances in which the test oath was constitutional. However, outside of the court, the political environment was changing dramatically. As Reconstruction progressed into the late 1860s, the hegemony of the radical Republicans in the state legislature dwindled markedly as moderate Republicans broke with the radicals because they felt that the punitive measures against Confederates were too harsh, and Unionist Democrats, those who had actually supported the Union during the war, were beginning to ally with Confederate Democrats in an effort to oust Republicans. And the turning points occurred in the legislative elections of 1869 and 1870, when the Democrats took back the legislature. They lost no time in repealing all test oaths. In 1870, the teachers, attorneys, and suitors' test oaths were all repealed, and in 1871, the election officers and voters' test oaths were rescinded. In addition, in 1871, a simple oath of allegiance to the Constitution of the United States and of West Virginia became all that was necessary to serve in government. And thus, legislative enactments ended the era of the oath. But as sort of an anticlimax, the next year, 1872, West Virginia's court finally found them unconstitutional, even though none were on the books, after the United States Supreme Court reversed their decision in Pierce versus Carskadon. However, despite the fact that the court finally got with the Democratic times, they were still dramatically affected by the Democratic takeover. The Democrats convened a constitutional convention in 1872. Notable delegates to that convention were the Confederate horse dealer John T. Pierce and Charles James Faulkner, both of whom, along with many other Confederates, were disenfranchised during Republican rule. The new Constitution added a fourth seat to the court and also held that elections for all four seats were to be held in 1872. And as the Democrats were now in the ascendant in the electorate, Brown, Maxwell, and Berkshire, who all serving as Republicans on the court, were defeated, and the court was placed firmly in Democratic hands from 1873 until 1901. And as these cases illustrate, the political definition of enemies and their corresponding punishments is quite malleable and changes with the political currents. The justices of the court had to deal with such vague and complicated issues as military rule and the prosecution of belligerents and insurgents even after war had ended, and how to define enemy when enemies and non-enemies alike were fellow citizens. The answers to their questions would subsequently change as the political currents changed in West Virginia during Reconstruction, and their Unionist sympathies are important to gauge when trying to understand their decisions and how they reach them. And thus the test oath cases shed light on the early history of the court and also provide an interesting personal dimension to legal history. Above all, the test oath cases illustrate that the definition of enemy changes based on who controls the mechanisms of the rule of law. When Republicans were in power, most Democrats and all Confederates were enemies. However, that designation changed overnight once the Democrats took back the legislature. And thus, the test oaths show the ambiguities inherent when trying to label some of your fellow citizens as enemy.
Poor Ralph Berkshire gets elected to the court, and he's one of 3 justices, and they start the whole business by drawing lots. You know, they're all elected. They don't know how long they're going to serve. One's going to serve a 4-year term, another an 8-year term, another a 12-year term. So Ralph Berkshire, of course, drew the short lot. So he serves his term, runs, and loses to Edwin Maxwell. Well, then William Harrison resigns because of illness, and so Berkshire gets appointed in 1868 and is simultaneously running for office in 1868. Well, he was elected in 1868, thinking he was finally elected to a full 12-year term on the court, but the 1872 Constitution cropped that term, and in fact, when he ran in 1872, he lost. So his tenure on the court sort of spans the same arc that Josh was recapitulating for you. The Reconstruction-era test oaths served to define enemies by clearly demarcating those who couldn't take the oath. At the same time, they served as a means of punishing the enemy, because as the enemy could not in good conscience take the oath, they were in effect barred from civil life. Similarly, in 1882, the West Virginia legislature passed a law that defined a new class of enemies, conspirators, and approved strong prosecution standards and appropriate punishment. We come now to our second group of cases involving the Redmen's Act. The 1882 statute, known as the Redmen's Act, was a legislative attempt to deal with a new brand of enemies who West Virginia legislatures felt were closing in around them. The original intent of the act was to target fraternal and secret societies. However, the uses of the act began to transcend the original intent, allowing the prosecution and enhanced punishment of conspirators. The Redmond Act cases heard in the Supreme Court exemplify how this new class of enemies can be legally manufactured and, perhaps more importantly, punished more severely than others.
Chapter 135 of the 1882 Acts of West Virginia, passed on March 24th of that year, is more commonly referred to as the Redmond Act. And the main purpose of the statute, as stated in its preamble, is for the punishment of unlawful combinations and conspiracies to injure persons or property. The statute targets two or more persons who conspire or combine together for the purpose of inflicting any punishment, or for the purpose of destroying, injuring, or taking and carrying away any property which is not their own. When crimes are committed as part of such a conspiracy, they are automatically treated as felonies, even when the individual crimes without the taint of conspiracy could have been considered misdemeanors. In addition, perhaps the most powerful portion of this statute is that which allows for the presumption of conspiracy. Just because two people commit a crime together, or one is on the scene of another's commission of a crime, it's automatically assumed to be a conspiracy, and in the absence of satisfactory proof to the contrary. In addition to broadly defining conspiracy and conspirators, the statute also provides expansive powers for their prosecution. For example, witnesses were not allowed to refuse to testify at Redmond Act cases, but they were protected from implicating themselves in a conspiracy in the hope that they would implicate others in the conspiracy. In addition, the governor was given expansive powers to call on the military, special policemen, and detectives to root out conspiracies throughout the state. The Redmond Act, with its expansive grant of power and broad definition of conspiracy, can be understood as a legislative response to the perceived enemies of the period. Originally, the Act targeted secret and fraternal organizations. Specifically, the Act states that it targets two or more persons under the name of Red Men, regulators, vigilance committee, or any other name, or without a name, and subsequent Supreme Court decisions would further define the original intent of the Act as dealing with lawless bands of men who were in the habit of inflicting punishment and bodily injury upon peaceful citizens, who organized in secret and appeared often in disguise, and who presumed to take the law into their own hands. Such secret and fraternal organizations as the Red Men were thus seen as enemies of the peace in the late 1800s and in the early 1900s in West Virginia. The Improved Order of Red Men is a secret and fraternal lodge which is still in existence today and traces its lineage back to the radical Sons of Liberty groups during the American Revolution. Historian Fred Barkey has done some work on the Red Men in West Virginia in the late 1800s and early 1900s, and he finds that their lodges were often seen as radicals because they organized miners in the coal fields secretly and publicized the plight of miners and provided comfort for miners, their communities, and their families. And thus, the conjunction of secrecy with which the lodges acted and their perceived radicalism in the labor movement caused them to be treated as enemies by the government. And thus, this act was originally targeted at such organizations. However, as time passed and the act remained on the books, new and different groups became to be targeted by the act. And the most really interesting case which came before this court regarding a prosecution under that act was the 1910 case of State versus Pissionary, in which 19 members of the Black Hand appealed their conviction under the Redmond Act. And in the late 19th and early 20th centuries, the Black Hand was a notorious group in northeastern America, composed primarily of Italian immigrants who resorted to extortion and assassination to raise money, and they were a secret and fraternal lodge active in West Virginia. And on March 27, 1909, authorities in Fairmont and Marion County arrested 19 members of the Black Hand and charged them with the rather vague crime of Black Hand practices. The case arose when Orazio Berardelli, an Italian youth in Fairmont, went to the prosecuting attorney of Marion County and told him that several members of the Black Hand had approached him and threatened his life unless he paid them for a forced initiation into the Black Hand. The prosecuting attorney gave Berardelli the money so that he could be initiated and serve as an informant. Based on Berardelli's testimony, authorities subsequently arrested Francisco Piscioneri and 19 others composing the leadership of the local Black Hand Lodge. And thus, it created a sensation throughout the state and was a subject of much intrigue, as can be seen by the newspaper articles in the Fairmont West Virginian. After a sensational trial in which even the court interpreter's life was threatened by the defendants, all 19 were found guilty of what the Fairmont West Virginian labeled nefarious practices and were sentenced to the state penitentiary. However, the judgment was suspended on a writ of error to the Supreme Court.
On appeal, the Supreme Court upheld all of the convictions. But the story of how the court ended up holding that is an interesting one and has some parallels to today. For example, if you think the issue of, here's the actual, by the way, the writ of error that the 9 men brought to the Supreme Court. This is a letter that was written by the prosecuting attorney to the Attorney General. And you know, these days, you sometimes hear fusses about how much it costs to keep defendants in the regional jail pending trial. Well, that's exactly what this letter is complaining about. If you can see, we have at this time 10 of these prisoners who are blackhanders, as we call them, and they're costing us $150 a month to keep. Can you please hurry up and print the record so this case can be heard? And I can proudly say that my predecessor, William Matthews at the time, he ended up receiving a letter from Attorney General Conley, and the very next day the printed record was in fact filed. And the case was argued early in 1910, but in fact the decision didn't come down until November of 1910. This is a telegram that again came to the clerk at that time. Please send down the mandate in Black Hand case. We want to get prisoners off our hands. On appeal, the verdict was objected to on the basis of entrapment, and the court upheld that practice. And the court further held that under the Redmen's Act, the presumption that was contained in the statute was in fact a rebuttable presumption, and that therefore, as previously held by the court, the act was constitutional. What this presumption did was essentially give the prosecution a tool. If the prosecution could establish that 2 or more persons were present when a crime was committed, that was automatically conspiracy, and the burden shifted to the defendant to come forward with evidence to establish the absence of a conspiracy. A very difficult thing to do. The act was originally focused on secret societies, but most of the cases concerning the act that came to the Supreme Court concerned individuals committing crimes together. It became to be a criminal conspiracy statute. In 1896, the court decided the case of State versus Bingham, upholding the constitutionality of the Redmen's Act, because the presumption it created, the court held at that time, was rebuttable and therefore made it constitutional. Several other cases came to the court during that time, and mostly it was clear that the courts out in the counties had difficulty fashioning jury instructions because of the tricky nature of this presumption. But finally, in 1975, in the case of Pinkerton versus Farr, the court found the Redmen's Act unconstitutional. In light of the recent U.S. Supreme Court decision in Mulaney versus Wilbur, the court held that the presumption created under the Act is in fact unconstitutional. It tramples upon the presumption of innocence and so forth. However, the statute's never been repealed. It's still on the books, as we say. West Virginia Code 6167 is the Redmen's Act, and it says unconstitutional. See notes. I see a couple of legislative attorneys taking some notes. One little interesting side note is that in State versus Postlethwaite in 1977 may have, if any of the Piscioneri family are still around, they might be able to get an expungement. In the case of State versus Postlethwaite, the court held that its ruling in Pinkerton versus Farr was fully retroactive.
Ultimately, the cases concerning the Redmen's Act show that, similar to those regarding Reconstruction-era testos, statutes and the judicial decisions defining them can operate to classify new enemies and corresponding punishments. Just as the testos identified enemies based on who refused to take them, so too did the Redmen's Act legally sanction a presumption of guilt. and a new class of criminals, those of conspirators, subject to more severe penalties and new judicial standards, such as the presumption of conspiracy. Thus, both the Red Men's Act and the Test Oath reveal one of the fundamental ways in which those who are responsible for the rule of law react to the fears of enemies in their midst, by assigning guilt and defying the now guilty to prove their own innocence. In Reconstruction era West Virginia, you had to take the test oath to prove your innocence. Before then, you could have been a Confederate sympathizer. Likewise, under the Red Men's Act, just because you commit a crime with someone else or are at the scene, it's automatically presumed to be a conspiracy, and you must prove otherwise. Thus, statutes and the decisions upholding them can not only classify new enemies, but can sometimes arbitrarily assign citizens into those camps and defy them to prove their own innocence through the reversal of the presumption of innocence. And as the industrial age took hold in West Virginia, it brought with it a new class of enemies, and it proved only a matter of time before those prosecuted for conspiracy under the Red Men's Act shifted from actual red men and black handers to striking coal miners.
We come now to our third group of cases, the martial law cases. In the violent miners' strikes of 1912 and 1913 along Paint and Cabin Creeks in Kanawha County, miners, socialists, labor agitators, and newspapermen were pursued as enemies under the Red Men's Act and a related statute that we will discuss that some call the Red Men's Law, and also by the West Virginia National Guard in repeated periods of martial law. Once again, the West Virginia Supreme Court of Appeals and the government itself, aided by the Supreme Court, declared large numbers of West Virginians to be enemies and defied them to prove their innocence. The Paint and Cabin Creek strikes provided a unique challenge to the rule of law in West Virginia. In order to deal with this challenge, strikers and other agitators were charged with conspiracy and subjected to martial law and military tribunals. This treatment calls into question the inviolability of the rule of law in this type of situation. 3 cases decided by the Supreme Court of Appeals during the Paint and Cabin Creek strike eras illuminate the government's power to invoke the rule of law to classify and condemn enemies.
In order to explore the legal ramifications of the 3 martial law cases, it is first essential to describe the historical context of that period, which made martial law seem a viable option in West Virginia. Strikes broke out among miners along the Paint and Cabin Creeks mine districts in Kanawha County just south of Charleston in 1912, and the strikes quickly turned violent when the striking miners clashed with the mine operators who were importing scabs, who are non-striking miners, to break the strike, and also employed private gunmen of the notorious Baldwin Felts Company. And as a result of this violence, Governor William E. Glasscock declared martial law along Paint and Cabin Creeks on August 30th, 1912. This would prove to be only one of 3 impositions of martial law in that area over the next year. By declaring martial law, Glasscock turned citizens in that region into enemies. Automatically, residents in the martial law zone caused one to be treated as a belligerent, and, as the Supreme Court would later hold, outside the protections of civil law and even of the West Virginia Constitution. However, striking miners in Kanawha County were not the only threats and the only enemies at this time. Rather, enemies came from outside the state in the form of labor agitators, socialists, and newspapermen. And one of the most famous of these outside agitators was Mother Jones. Mother Jones was a nationally recognized labor leader, a fixture at rallies, strikes, and protests nationwide, and an organizer for the United Mine Workers and a socialist. At the time of the strikes, Mother Jones was 83, and after the strikes turned violent, she immediately rushed to the scene to lend her help and her notoriety. During this period, she took up the full gamut of causes, from child labor to women's suffrage to, as in this case, the alleviation of the plight of industrial workers. The Socialist and Labor Star, which was a Huntington-based socialist newspaper at this time, said of Mother Jones, whom they called the Angel of the Mines, The story of Mother Jones has been the story of the labor war that goes on and must go on in every country, where workers are exploited to make profit for shirkers, and always has she taken her place on the firing line. By her own admission, Mother Jones was a troublemaker. She once corrected a professor who was introducing her to an audience as a great humanitarian. She replied, "Get it right, I'm not a humanitarian, I'm a hellraiser." And Mother Jones would live true to her reputation during the strikes along Paint and Cabin Creeks. There she rallied miners, challenged them with very strong language to arm themselves to protect themselves against the Baldwin Felts Guards, raised their hopes with inflammatory rhetoric, brought the strike national publicity, and defied the governor on many occasions. Following a lull in the initial violence in the martial law zone, martial law was repealed on October 15, 1912, only to be reimposed by Governor Glasscock on November 15th. The second period lasted until December 12th. However, the worst violence had yet to occur, and in early 1913, skirmishing once again broke out between striking miners and mine operators and their gunmen, resulting in the Baldwin Felts Guards firing into the strikers' tent encampment at Holly Grove. During this violence, a miner named Sesko Estep was killed. Here is Maud Estep, his wife, and his child. Sesko went on to become a martyr for the miners during this period, and Mother Jones rallied other miners at his funeral. This engagement resulted in another declaration of martial law, the third, on February 10, 1913. That same day, the worst violence occurred when striking miners, in revenge for this attack, attacked the tent encampment of the Baldwin Felts Guards in what's been known as the Battle of Mucklow. Following this battle, Mother Jones and 47 others were arrested for their involvement in the violence and complicity and conspiracy to commit violence. Mother Jones and others were now prisoners of the West Virginia National Guard.
To deal with the exigencies of the strike and the threat it posed to law and order, the government relied on several strategies, primarily the declaration of martial law, but also the striking leaders and their cohorts were arrested and charged with conspiracy under the Redmen's Act. But in addition to the Redmen's Act, the West Virginia Code gives the governor certain powers to act at a time of insurrection. West Virginia Code now 512 says that the governor may cause to be apprehended and imprisoned all who in time of war, insurrection, or public danger shall willfully give aid, support, or information to the enemy or insurgents, or who, he shall have just cause to believe, are conspiring or combining together to aid or support any hostile action against the United States or this state. So by declaring martial law, the governor had given to himself substantial powers to arrest and detain insurgents. Some editors at that time called this action by the governor an exercise of the Redmen's Law, regarding Governor Hatfield's declarations, and so on. And here's a contrast with the provision that I just read on the left, and on the right, the normal civil liberties that we all enjoy. The right to be indicted by a grand jury, the right not to be deprived of your liberty without due process of law, and, importantly, in some of the subsequent cases, a provision in our Constitution that says the military shall be always subordinate to the civil power. As part of their powers under the Redmen's Law, both Governors Glasscock and Hatfield relied on the West Virginia National Guard to preserve order. And several important and far-reaching challenges were brought against these legal recourses used by the government to restore order and to punish strikers. A series of three cases, brought against the power assumed by the governor and the military in the martial law zone and throughout the state. In all of these cases, counsel for the state were Attorney General Conley, Lieutenant Colonel George S. Wallace, who was the Judge Advocate General of the West Virginia National Guard, who ended up prosecuting about 200 civilians that were tried before the military commissions in the martial law zone. The first of these key cases was that of Nance and Mays, decided in December of 1912. Now, by this time, the court was back in Republican hands. All of the justices that decided the Nance and Mays case in December of 1912 were Republicans. The senior justice was a man named Henry Brannan. He's well known in West Virginia politics as the only politician that I know of to have been elected first as a Democrat, served a 12-year term, and then changed parties, ran as a Republican, and served a full 12-year term. So at the time the Nance and Mays case was decided, he was closing in on the end of his second full 12-year term, but all of the rest of the court were all Republicans. Justice Poffenbarger, however, authored the opinion of the court in Nance and Mays, and at issue there, of course, was, does the governor have the power to declare martial law? Nance and Mays had been arrested in the martial law zone for actions that had taken place between the first declaration of martial law and the second declaration of martial law. They were arrested for offenses that in peacetime would be misdemeanors. Nance was arrested for obstructing an officer, which carried a normal penalty of $50 to $500 and a jail term of up to 1 year. He was sentenced to 5 years in Moundsville. Mays, who was arrested for preventing by threats or intimidation someone from working in a mine, normally carried a $50 to $500 penalty or 10 to 90 days in jail. He was sentenced to 2 years in Moundsville. The Military Commission therefore gave more severe punishment than either of these individuals would have received in a civil court. During this entire time, the criminal court with jurisdiction here in Kanawha County, which was then known as the Intermediate Court, was open and operational. All of the justices of the peace were here and working. The Supreme Court of Appeals was obviously here and working. So how then did the Military Commission, under the declaration of martial law, have the ability to impose a more severe penalty on a crime that took place between the periods of martial law? Well, here's how it happened. It didn't have anything to do with the governor's orders, but it was in fact orders issued by C.D. Elliott, who is the Adjutant General, and his General Order number 23 governed the jurisdiction of the military commissions and their ability to impose penalties. And I read, "The Military Commission is a substitute for the criminal courts of the district covered by the martial law proclamation, and all offenses against the civil laws as they existed prior to the proclamation of November 1912 shall be regarded as offenses under the military law. And as punishment, therefore," here's where it's good, "the Military Commission can impose such sentences, either lighter or heavier than those imposed under the civil law, as in their judgment the offender may merit." When you contrast this to what the governor's powers are under West Virginia Code 512 and 513, the governor doesn't have power to enhance criminal penalties. He does have powers to call out the omission, to arrest and detain individuals, but this is a broader reach, and so that was the heart of the challenge in the Nance and Mays case. And focused upon by the court was, notwithstanding the fact that all the courts were still operational, and notwithstanding the fact that the crime took place not during a period of martial law, could these individuals nevertheless be tried and punished as they were. Justice Poffenbarger authored the majority opinion of the court that in fact upheld everything that happened here. It said that a crime committed during the interim between two periods of martial law is nevertheless covered. But what was the reasoning? Poffenbarger looked to the governor's constitutional authority to in fact call out the militia. Read that together with the statutory powers that I've already talked to you about, that some refer to as the Redmond's Law. And then said that all of these civil liberties about a trial by jury and the subordination of the military to the civil powers, those all have to be read and harmonized with the implied presumption that the people in 1872, when they enacted our Constitution, did not intend to repeal the state's inherent right to preserve itself. That's almost verbatim the syllabus point. So that the state has an inherent right of self-preservation, an implied right of self-defense, so to speak, that can't somehow be silently repealed by these other provisions in the Constitution. But it was a 4-to-1 decision. And before I talk about the dissent, the other point that the majority made is kind of important to bear in mind. Poffenbarger argued that the insurrection itself operated to displace constitutional and civil law. That it wasn't the governor's declaration of martial law that did it. All the governor's declaration of martial law did, he said, was to recognize that the insurgency had done away with constitutional and civil liberties protections. Merely recognize the state of affairs that already existed. Here's the writ of habeas corpus that Mays brought. There's Ira Robinson. He was from Grafton. And he dissented. And he would break from his colleagues in all three of the cases that we're going to discuss in this section. Among other points, Robinson pointed to a stark contrast between the 1863 West Virginia Constitution and the one that we operate under now. For example, this clause regarding the privilege of the writ of habeas corpus, this is how it reads in the federal Constitution and in the 1863 Constitution. You see the limiting clause. Except when in time of invasion, insurrection, or other public danger, public safety may require that privilege of writ of habeas corpus be suspended. That was amended. And that accepting clause was removed from the Constitution that we now operate under. And so Robinson argued that that's certainly one thing that the majority should have taken into account. Moreover, Article 3, Section 12 of the Constitution says that the military is subordinate to the civil power, and that no person shall be tried or punished by any military court for any offense that is cognizable by the civil courts of the state. Robinson argued that all of these offenses were cognizable by the civil courts of the state, which were still in operation. And in fact, he had strong words for his colleagues, who he argued rendered a tortured reading of what was otherwise plain language of the Constitution. And here's what he said in his dissent. There's no ambiguity in these words. He who runs may read. A further test to the ability of the military to try civilians in its tribunals occurred in In re Jones, Boswell, Batley, and Paulson, which was decided in March 1913. But before I talk about that case, I want to discuss one more constitutional provision. Robinson, in his dissent, pointed to Article 1, Section 3 of the West Virginia Constitution, which was not mentioned, much less distinguished by Justice Poffenbarger in his majority opinion. Provisions of the Constitution of this state are operative alike in a period of war as in a time of peace. Any departure therefrom, under the plea of necessity or any other plea, is subversive of good government and tends to anarchy and despotism. Now that's pretty much on point. What Robinson argued was that what Poffenbarger had done and what the governor had done is precisely what this section prohibits, is to operate under a plea of necessity, suspend the guarantees of the Constitution in flagrant violation of the plain language of the Constitution. Why construe it when the language is otherwise plain, is basically what Robinson argued. So Mother Jones was arrested, along with three other colleagues, all labor agitators. They were on their way to see Governor Glasscock. She was later taken on a train back to Pratt and held there in military prison. They were arrested outside the martial law zone in the city of Charleston. And she was leading a protest to the Capitol, and police transported her back. This was where she was kept. She was lucky. This is a house in Pratt that was on the National Register of Historic Places until 1997, when it was demolished as the Mother Jones Prison. She was lucky that she got to stay here because everybody else was kept in what they called the bullpen, which was a series of train cars surrounded by barbed wire at the head of Cabin Creek. But she was here, and in fact, Governor Hatfield, when he was inaugurated in 1913, Governor Hatfield had been a medical doctor, and one of the first things he did after being inaugurated was visit the strike zone and visit Mother Jones and try to minister to the sick there. But again, this was torn down in 1997 by the owners. A total of 47 participants in the strikes were arrested and charged by military authorities with conspiracy to commit violence under the Redmen's Act. Again, they were to be court-martialed in the martial law zone and prosecuted by Judge Advocate General Wallace. The attorneys for 4 of the defendants petitioned the Supreme Court of Appeals for writs of habeas corpus in order to argue the constitutionality of the military courts trying civilians. And on February 26 of 1913, the court held habeas corpus hearings for Mother Jones, Charles Boswell, who was the editor of a socialist newspaper here in Charleston, Charles Batley and Paul Paulson, who were both UMWA organizers. During the case, the constitutionality of military tribunals were questioned, as were the military powers of the governor and the legality of arresting Mother Jones outside of the martial law zone. The court, of course, reaffirmed its decision in Nance and Mays. Interestingly, Poffenbarger, in the Nance and Mays case, apparently wrote a pretty hurried opinion, and those of us who work at the court have seen this before in prominent cases. The court, the majority, will write a hurried opinion. The dissent was much more lengthy and much more scholarly. Then Poffenbarger came back and wrote a separate concurring opinion in Nance and Mays after the fact. Then comes the Mother Jones case, where the parties again attack the court's conclusion in Nance and Mays. And you read Poffenbarger's majority opinion in the Mother Jones case, it is a lot more scholarly, and he's in fact rebutting Robinson's dissent to a large extent. It's a fascinating opinion to read. Of course, the court, and again in an opinion authored by Poffenbarger, reaffirmed its prior decision and further held that the governor has power to cause to be apprehended in or out of the martial law zone those who are fomenting the insurrection as a consequence of the general war powers. Poffenbarger made an interesting line of reasoning. He said, essentially, I don't know what the fuss is with all the civil liberties stuff and trial by jury. The police can shoot somebody in self-defense. That person's dead. They're deprived of their life without due process of law. Clearly, our constitutional scheme contemplates situations, extreme as they may be, where the civil liberties can be set aside. Robinson, in his dissent, reiterates, of course, his earlier criticisms. He argued that he had no problem with the governor having the ability to call out the militia. His argument was that the militia should aid the normal civil process. He said, send the militia into the strike zone to bring Mother Jones and try her in the normal criminal courts down here. The militia's job is not to supplant the civil order, but instead to support it. And I quote from his dissent. Instead of recognizing the true order of the statute, he's referring there to the governor's powers under the Redmond Law, whereby militia is an aid to the civil authorities, the law is reversed, and the civil authorities are used to aid the military power. Verily indeed has the military power been made absolute, independent, and dominant in West Virginia! Exclamation point in his opinion. He argued that the Cabin Creek District is not an enemy of the state. He said they haven't seceded from the Union. They haven't seceded from the state. And what's more, the military authorities didn't just rely on the powers granted the governor. They, in fact, relied on their own orders in order to be able to enhance the sentences and enhance the penalties.
The third martial law case would test the powers of the governor to suppress dissent and exert himself militarily outside of the martial law zone. After Governor Glasscock left office in early 1913, Governor Henry D. Hatfield inherited a portion of his state under martial law. Under his leadership, a settlement was reached in April of 1913. However, that settlement did not satisfy the majority of the striking miners who renewed their strikes along Paint and Cabin Creeks. In addition, Wyatt Hamilton Thompson, known as Comrade Thompson, harshly criticized the Hatfield settlement from the pages of the Socialist and Labor Star, the Huntington-based socialist newspaper, of which he was the editor. As a result of his harsh criticism of the Hatfield settlement, Governor Hatfield ordered the National Guard to Huntington to destroy Thompson's presses, to suppress a particularly inflammatory issue, and to arrest the paper's editors. Thompson was subsequently arrested in Cabell County and transported to Kanawha County, where he was turned over to the military authorities in the martial law zone. It was charged that Thompson was disturbing the peace, inciting violence in the martial law zone through his newspaper's circulation in Kanawha County, and was therefore hindering the conclusion of a peaceful settlement of the strike.
When he was released, Thompson brought a writ of trespass in the Cabell County Circuit Court. He sought to recover damages to his printing plant in the amount of about $10,000 against Governor Hatfield and the military officers that Governor Hatfield sent over to Cabell County. Hatfield brought a writ of prohibition in the Supreme Court. The court issued a rule to show cause, and the case was argued. In the court's opinion, Hatfield versus Graham, Judge Williams from Greenbrier County authored the majority opinion and upheld the governor's ability to act in that case. Building upon the prior cases of Nance and Mays and Ex parte Jones, the court further extended the governor's ability to act at a time of martial law. The court held that the governor's actions were essentially not reviewable. And I quote from the syllabus, "The office of governor is political, and the discretion vested in the chief executive by the Constitution and the laws of the state respecting his official duties is not subject to control or review by the courts. His proclamation, warrants, and orders made in the discharge of his official duties are as much due process of law as the judgment of a court." Further, the governor could extend this power by, quote, "temporarily suppress any newspaper published in the state having a circulation in the martial zone and containing articles which he has reason to believe will encourage a continuation of the disorder therein." So the governor's powers could reach, indeed, outside the martial law zone for any newspaper that was fomenting the insurgency within the martial law zone. Robinson's dissent was essentially more of the same. You know, he used the circumstances of this case to say, see the parade of horribles that I said was going to happen back in the Nance and Mays case? That's exactly what's happening here. Yet a stronger example of the problems with our civil liberties. And the court's series of decisions were a subject of criticism at that time, not just from within the court itself. William Gordon Matthews was the president of the Bar Association in 1913. He had run for the court in 1908 and lost, and he was the son of a former governor, Matthews, and he was president of the bar. And when the Bar Association met in Wheeling, he was the one who gave the keynote speech. And in a speech that runs this is the little volume that the Bar Association used to publish every year about their proceedings. His speech runs about 25 pages in this book. And every word of it is a condemnation, very gentlemanly condemnation and respectful, but a condemnation of the court's opinions in Nance and Mays and the Mother Jones case. He makes a very interesting historical constitutional critique, focusing largely on the fact that when our Constitution was adopted, people in the border counties had experienced this during the Civil War. That when one side would come in, they'd immediately declare martial law, everybody was enemies, we're going to summarily try them and execute them. And there was a well-known case out of Greenbrier County where an individual who was well-known to the community as not really a sympathizer one way or the other was in fact summarily tried and executed. And the people in Greenbrier County still remember that case to the day. And he cited that as background for what was in the frame of mind of the folks who adopted the 1872 Constitution. The provision about the military always being subordinate to the civil authorities, about that the provisions of this Constitution cannot be suspended under any plea of necessity. It's interesting who attended that meeting in Wheeling. Out of all the sitting justices on the court, only Ira Robinson attended. It wasn't just from within the state that the criticisms came. In fact, because of Mother Jones' publicity, in fact, while she was held in the house at Rand, there was a reporter from Pittsburgh who didn't take the train because the train was controlled by the guards, walked all the way up the creek, met in the basement. She had a trap door where she was stayed, and she would meet with people and pass notes back and forth. So the reporter from a Pittsburgh paper met with Mother Jones, interviewed her over the course of 2 days, went back and published these interviews, and it generated a lot of criticism in Washington and in other places. And so the Senate comes to Charleston to hold investigations as to what exactly happened. And as reported, of course, in the Socialist Labor Star, the senators are astounded by the West Virginia revelations. In addition, a noted legal scholar, Charles Fairman, wrote in his book, The Law of Martial Rule, in 1930 that only the period of the Civil War can afford a parallel to this episode. He essentially characterized the governor's use of martial law powers and the military commissions as overreaching. This issue is important for today, as a contradiction still exists between the powers afforded the governor in the statute versus the constitutional tensions, the restrictions on the plea of necessity, and requiring the military always to be subordinate to the civil power. The denunciation over the suspension of the civil law is certainly an issue that is discussed today in different contexts, and certainly this history helps to inform that discussion.
Eventually, after more than a year of striking, a more suitable settlement was finally reached, and the miners returned to work. Mother Jones, after her Supreme Court trial, was sent back to the martial law zone, and her and the others were tried by a military commission and found guilty. However, Hatfield, after the settlement was reached, pardoned all the prisoners in an attempt just to put the memory of the strike behind him. The martial law cases relating to the Paint and Cabin Creek strikes once again highlight how those who control the mechanisms of the rule of law control the designation of enemy. In addition, this example shows how sometimes that designation can seem quite arbitrary, in that by a proclamation of martial law, every citizen in that area was automatically considered a belligerent. And as with the test oaths and the Red Men's Act, those in the martial law zone, by being presumed to be belligerents, had to prove their own innocence, but this time the civilian justice system was closed to them. A common theme running through all of the cases and statutes discussed today is the need felt by one segment of society to label the other as an enemy, to inoculate the body politic from their dangerous influence, and indeed to create a new society in which the enemies would play no part. And thus, although it seems that at times the designation of enemy is arbitrary, it's important to remember that many times the employment of that designation is quite calculated on behalf of those who are responsible for the rule of law. After the Civil War, radical Republicans possessed an image of an ideal society grounded in a physical locale, the brand new state of West Virginia. The Supreme Court of Appeals, composed of strong Unionists, was instrumental in helping to enforce this Republican vision by upholding the powers of the legislature to define enemies and circumscribe their rights accordingly. The effort to root out conspiracies under the Red Men's Act was a further example of an attempt to enforce a vision of society, one in which the rule of law was sacred and would not be undermined by secret organizations who attempted to take the law into their own hands. And lastly, the prosecution of striking miners and the imposition of martial law was an attempt to create an industrial West Virginia, part of a larger process throughout the state in those decades. A society of progress and material gain, and the court firmly ruled on the side of industrial advancement. What is most informative about these cases is how the word enemy was used. By simply employing this word, former citizens, oftentimes law-abiding ones, found themselves outside the protections afforded by the rules and norms which govern the rest of society. With the designation enemy, they were no longer members of the body politic, but found themselves set up in opposition to it. With a simple word, their status changed, their rights dissolved, and they fell outside of the protections of the rule of law.
That concludes our presentation. We'll be happy to entertain questions. Thank you all very much for your attention. I know that sitting in these 80-year-old chairs for a little over an hour isn't easy, but we wanted to go ahead and get through the material without a break. So if there were questions, comments. Yes, sir.
Sure. Less than 2 miles from here, a group of analysts at the time in a electrical factory called City through straws as to who was going to assassinate President Clinton.
Really?
And he left here, and the rest is history. As I understood the presentation, the Records Act was still in effect at that time. And clearly the conspiracy was, they had a group of them up there working in that area. Now, the governor at that time, I guess, maybe known about it, declared martial law. Whether you want to make the kind of distinction between an anarchist and terrorists.
Mm-hmm.
Let's fast forward today that under the current state of martial law, West Virginia powers the government has to declare martial law and deal with threats like that if they are done. Counterterrorism, of course, is the key to the identification.
Mm-hmm. Right. I guess the question is, what powers would the governor have today if the governor were confronted with a similar situation?
Well, there's a very prominent person from the military that says West Virginia is ripe for terrorism.
Well, the governor has general powers to deal with insurrection, and certainly the Redmonds Act is unconstitutional, no longer on the books, but there are other mechanisms to deal with conspiracies. But there's been harsh criticism of what was done in 1912 and 13 with regard to the declaration of martial law and the way that the militia was used to carry out those orders. And I commented on that with regard to the enhanced penalties that were in front of the military commissions. I mean, it's one thing to use the militia to restore civil order, but it's another, it was argued, to use the militia to supplant the normal civil liberties that would apply. And again, I don't mean to take a position on this debate one way or the other because it's a debate that's going on nationally, but we simply wanted to present this information for everyone's consideration as part of that debate. Tom?
Yeah, thank you for a very presentation. I was going to press that.
Yeah, thank you.
Because I use this stuff often, so I'll just be the first rather than go to the substance of these cases, I just want to ask a little procedural question, see if you have an opinion on this. When tough political issues come before this court, we just use the gambling case for example. And I'm not saying about American case one way or another, but this court has, I'm here long enough to know that the court got this case, and sometimes when it feels like, well, that's not much merit in that case, the majority of now feels it, then we're not going to take it up because it's just something easy to see. But I just wonder if you can tell from your reading these things whether the court felt that it had that option, or whether it felt in earlier times to discuss something, say we're going to let it stand without speaking. And then, more interestingly, whether the court chose to take cases because it felt some either political responsibility or opportunity or whatever, the historical act to say, my God, we're going to validate this, or do we just say, well, the governor did it, and we're going to refuse. So was there such a common practice then of taking everything that pretty much came up that really wasn't on the table as an option back then? Things have changed somewhat. What do you think about that?
It does. There were fewer cases filed, and there were more cases taken. And I think that the court's issuance of rule to show cause in all of the martial law cases, they all came as habeas petitions originally to this court. But from reading the opinions, Tom, I think the answer to your question is that the court was very much on the side of trying to weigh in on this issue and uphold and support the current approach to trying to deal with these enemies, whether it was during the test oath time or whether it was later during the martial law cases. That there was a willingness, and it comes through very clearly when you read the language of the opinions that the court, at least the majority, and also with Justice Robinson's dissent. I mean, he clearly thought that the issues were very important issues for the court to consider. So, and I don't know of any instances where an important case would have been brought and the court just dodged it. But that kind of instance would be a lot harder to uncover than what we have uncovered here.
Under those historical circumstances, you can certainly understand why there would be, I don't say enthusiasm is the word, but more activism.
But what you could see from the headlines was, some of the Gazette headlines, was that, this whole business about what was going on in the strike zone wasn't the only news of the day. Diaz and Grover Cleveland's wife getting married, and I mean, it all had equal prominence. So it makes you kind of wonder. I didn't really think about that that much until we just earlier this week found those headlines from the Gazette from that time period. It sort of puts it in perspective.
I just want to say, it's very interesting that this shift from Republican to Democrat the Republican in the court, ended up with the cases very much where the Republicans were, I guess, in power on the court, the Republican Party. And there was quite a willingness in both cases, early Civil War cases and in much later minor cases, to uphold executive authority and deprive people of lots of civil liberties because there's a greater willingness.
Well, with the exception of Robinson, I mean, he clearly had a different view of this, and he in fact ran for governor in 1916 and lost. And many people ascribe that to, he was beaten up in the press because of his opinions in these cases. It was not, clearly wasn't the majority view at the time. It didn't carry the day. Yes, Jeff.
The situation for me here, and I think it's huge, it's always been my understanding that the Constitution of the United States is the supreme law of the land, and that here in West Virginia, that our Constitution is the supreme law, so the social contract we deliver. Yet it seems time and time again that the courts were deciding for a legislative act and deciding for executive privilege of the governor, totally at odds with what I perceive as being the supreme law of West Virginia. Was this a matter of the court either being, I hesitate to use the word, but incompetent, not clear with seeing what the Constitution?
Well, the primacy of the United States Constitution and the applicability of all those guarantees to the states really wasn't fully formed at the time of the test oath cases, and again in 1912 and 13. I mean, the adoption of the 14th Amendment that happened, but not the full jurisprudence of applying all those rights and abilities to the states had not really taken hold in state courts just yet. There is a discussion about the 14th Amendment and about due process in these cases, but the main focus is on the state constitution. In effect, deciding without saying that, well, all right, the federal Constitution kind of sets the floor, but now let's put that aside and let's talk about what we have in West Virginia. And because ultimately the majority had to focus on the governor's powers under state law and the particular circumstances of our state constitution. Now, there was a reference, the United States Constitution says that we hereby agree to come to your aid in any domestic dispute when your governor calls us. I mean, I'm paraphrasing. But that was something that Robinson cited when he said, what's this business of, we can't, that the civil courts can't operate and we can't manage to do anything. We live in this federal republic. There's clearly protection under the U.S. Constitution that they'll come to our aid. We need to live within the rule of law. And so clearly it's just two visions. One, which the rule of law changes according to dire circumstances, and the other is that it doesn't. And that might be oversimplifying things, but. Yes, Barry.
Thinking about the test of cases, one of the parallels with the early certifying period of the U.S. Supreme Court. When they made first contact, they were often the first federal officers made contact with new citizens. We have a new state of West Virginia. You have these test of cases, and you have essentially trial judges that operate as trial judges, writing circuit and offering instructions to grand juries. And they hear from just instructions on the law and engage in what's called that. They offer wonderful essays, really on citizenship, but they also offer for a period of time, until the impeachment of the case, commentary, constitutional commentary. And I wonder if we have commentary coming from other channels, great jury instructions, judges might be commenting on the test. What are they saying in grand jury instructions? They take the opportunity to hear from business again to talk about issues.
Well, that's a very interesting question. Did you run across anything?
In the actual decisions on the test oath, some do veer. For example, one justice we quoted was Loomis, who sat in on one of the courts, and his decisions about 10 pages, and probably about the first 8 of those are a condemnation of the Civil War and condemnation of Confederates, and a rationale for not only test oaths are constitutional, but why we should have them. So there's more of the why factor, and he weighs in on much more than just the legalistic aspects of why this is good for our society and why we need this to, especially after the war, to purge our society of these elements. So.
But in addition to victims, you might find in actual cases, you find other folks out there who are weighing in, sort of hearing from what they connect to
That sounds like a good area for us to explore in the archives. It really does. You know, to look at some of the jury instructions and grand jury instructions and see whether or not there was an attempt to insert sort of a personal stake and comment. Better put that on the list for next year's intern, Josh. Yes, Steve. Uh-huh. Yeah. Uh-huh. Yeah. He did. He went by himself with his black bag in hand. Yeah. And Hatfield, Steve is right. Hatfield really inherited a mess. And when he was inaugurated in March 1913, he went with his black bag to Pratt, and he spent about 10 days taking care of the sick and saw everybody. And he really tried to mediate a settlement. Of course, he was criticized for that, and it went back and forth. But really, he was instrumental in bringing this whole episode to a close. Wow. Yeah. Yeah. Yes, Kirk. What was the sanction for falsely taking it? I guess it would be the same thing as perjury. I don't know. That's another thread we'll have to follow. I don't know if there were any prosecutions for people. You know, I know that guy was a rep, and then he's county commissioner, and he can't pass that oath. I'm sure that sort of thing happened, especially at a local level.
And it did happen at a local level with the voters' test oaths. First, only voters whose loyalties were suspect had to swear the oath. So if you went down to the polling station to register your vote, and someone else saw you, probably opposition party, said, "Oh, I think he was a Confederate, or he, gave food and medical supplies," then you had to take the oath. And that was mainly in 1865 when Confederates were just coming back from the war, and then in 1866 it was extended to every voter. And it's striking how many people were disenfranchised by this vote who maybe they could have got away with it but didn't, and that probably a large measure is due to the fact that they were proud of their service. It's still such a divided border state that they probably couldn't have gotten away with it, but perhaps they didn't want to try. So.
I seem to recall that was a highly significant compromise that somehow had an effect on the test goes. Also, something about the right of African Americans to vote in the state, and maybe the federal government. Could you say what that was? But I can't remember.
It was as Reconstruction was ending into the early 1870s, a Flick Amendment to the Constitution enfranchised African Americans in the state Constitution, and that was a compromise measure as the Republicans were losing so much power. It was one of the biggest pushes in Reconstruction by the radical Republicans nationwide was for African American suffrage, and that was ultimately what sort of a lot of scholars say doomed Reconstruction, because that was so unpopular throughout the rest of the country. Most white Americans just could not stand that, and that's why a lot of former Republicans even broke ranks. And so as Republicans were losing power in this state, they had a compromise measure with the Democrats to allow the Democrats to sort of have more enfranchisement, as long as the Flick Amendment was also passed to enfranchise African Americans in the state.
So in return for yielding somewhat on the test oath question, African Americans enfranchisement was made more solid, basically.
Yes.
Which helped the Republican Party, because in those parts of the state where there were African Americans, they were a solid Republican vote.
That's true, but probably only would have helped the Republican Party for less than a decade, until Jim Crow laws were instituted in black codes and things like that to restrict suffrage without actually.
But still, later in McDowell County and places like that, the Republican Party gained a lot of strength. As blacks started coming in and working in coal mines.
That's true, and nationwide until about the 1880s, 1890s, that's how a lot of the deep southern states were sending African Americans to the Senate.